Good afternoon, everyone. Try it again. Good afternoon. Uh, the time is now 12:52, and I'd like to call today's meeting to order. But before we proceed with today's agenda, I'd like to take a moment on behalf of the Planning Board to acknowledge the passing of a respected member of our community. The community recently lost Dr. Jude Onye Badu, a distinguished business leader, entrepreneur, and devoted family man. Dr. Jude was also a member of our colleague, Commissioner Billy Okoye. He was the owner of Metro Points Hotel here in the county, as well as other businesses. Through his work, Dr. Jude contributed significantly to the economic life of our county and continued to support many residents of this community. His legacy as a community builder, business developer, and supporter of many families will not be forgotten. On behalf of the Planning Board, we extend our deepest condolences to Commissioner Okoye, the entire Dr. Jude's family during this difficult time. I ask that we observe a silence, a moment in honor of Dr. Jude as we may his soul rest in perfect peace. One moment of silence. Thank you. And I call March 12, 2026 Planning Board meeting to order. We have the following board members with us today. Vice Chair Giraldo.
Good afternoon, everyone.
Commissioner Okoye.
Good afternoon, everyone.
And for the record, I'm Chairman Darrell Barnes. We will now move forward with the business at hand. Please note that the deadline for all participation, pre-registration, and for all submission of materials and exhibits was 12 noon on Tuesday before the Planning Board meeting. The order of cases for today's meetings are as follows. Item 2, 3, 4, and 5. The first item on the agenda is item 2, draft minutes from March 5th, 2026. We look for a motion.
Mr. Chair, I move that we approve the minutes.
I second that, Mr. Chair.
It's been properly moved and second. I will now call the roll. Vice Chair Giraldo.
Vote aye.
Commissioner Okoye.
I vote aye.
And I vote aye as well. The next item on the agenda is item 3A, legislative updates. We will now hear from staff Jordan Balcom Colbert.
Yes, good morning, commissioners. I bring to you 4 bills today, and the first one is HB 941, the hygiene products bill that I bought last week. Initially, we just did informational on this one, but we are going back to the table to get an opposition vote for Prince George's County. Again, the purpose of this bill is to require public restrooms in buildings to provide adequate supply of certain hygiene products, generally relating to those types of restrooms. As currently drafted, the bill would have a significant operational and fiscal impacts, specifically on our parks departments. Our parks department used hundreds of portable restrooms and vaulted toilets to provide restroom access in parks, especially near amenities like our athletic fields. The lack of water infrastructure cannot be reasonably modified to comply with this legislation. So the unintended consequences of the bill may be the removal of these restroom facilities from our parks and reducing public access to the restroom rather than enhancing and improving it. So for that reason, staff is recommending that we do an opposition for this bill.
Is there any questions for Ms. Jordan Balcom Colbert on this bill? Is there a motion?
Mr. Chair, I move that we adopt with the position or recommendations of council.
I second that, Mr. Chair.
It's been properly moved and second. I will now call the roll. Vice Chair Giraldo.
Vote aye.
Commissioner Okoye.
Aye.
And I vote aye as well. You may proceed.
Okay, so the next one I also brought previously is the chat box bill for as informational, the both boards suggested recommended amendments. This bill seeks to regulate the manner in which a developer designs and creates and operates and makes available these user to the state these chat boxes, including establishing safety and privacy protections for users. So last week we just did an informational, but this week we think that it is prudent for, especially coming from the recommendation for staff, for them to put a carve out for bi-county agencies. Our other coalition members like MACO have asked for a carve out for local governments. It's not very clear from the writing of the bill with whether that would encompass the commission as a bi-county agency. So staff has recommended to go back to the drawing board and include both agencies and local governments as recommendations from the board, because it's the optimal outcome. The effect that AI would have on county and municipality levels is a major concern.
Is there any question for Ms. Colbert?
And we don't need a vote. We're just going to do informational with some suggested amendments. Because I don't think we want to support the bill altogether, but we want to get our amendments in.
Yes, ma'am. Let me go to the next bill.
Okay, the next one is HB 1517. It's qualified projects regulatory downsizing. This one, we're just asking for informational as well. As you see, it establishes qualified projects for certain residential projects that have been subject to regulatory downsizing. And so there is a lot of ambiguity with this bill as how it's defined to target by regulatory downsizing, how that will be interpreted. The deed restrictive units don't match moderately priced dwellings units law that we have, and we'd like to offer some suggestions to match up the affordable housing provisions in respect to the counties, including those that have inclusionary zoning. So again, we're not asking for a vote, but we want to get some clarification on the bill and put the statement in from the board.
Enough. Any questions for Ms. Colbert?
None.
Seeing none, we go to the next bill.
Okay, the last one is also informational. HB 1538, accessory dwelling units, requirements or prohibitions. This, again, this is not for a vote, but we would like to submit an informational statement so we can get more clarification. What the bill does is require certain local law to authorize the development of at least one internal accessory dwelling unit and one external accessory dwelling unit on certain land, notwithstanding certain density limits. Among other things, it also limits the opposition of off-street parking requirements and certain accessory dwelling units. Staff have some questions regarding this bill, and so as you see in the statements, we want to put that in so that we can be on the record to get clarification around this legislation.
Very good. Job well done. Any other questions for Ms. Colbert?
No, just for clarification. So this would be for ADUs, is that right?
Yeah. Yes, sir.
And such a bill would allow seniors to age in place if necessary by having
yeah.
it. Okay, thank you. No further questions.
Thank you.
No
Ms.
problem.
Colbert.
All right. Thank you. Take care. Thank you.
Yes, ma'am.
Bye-bye.
We will now move on to the before with the consent agenda. Consent agenda item 4D and 4E. Is there anyone wishes to oppose staff recommendation on the consent agenda? And if not, what's your pleasure?
Mr. Chair, I move that we, after consideration of the record for items 4D and 4G, I move adoption of the staff's findings and approval of the items on the consent agenda in accordance with the recommendations of staff.
Second. Then properly moved and second, I will now call the roll. Vice Chair Giraldo.
Vote aye.
Commissioner Corrier. Aye. And I vote aye as well. We will move on to the regular agenda item. The first item on the agenda is item 5, preliminary plan of subdivision 4-22067, Morton Farm. We're now here from staff.
Good afternoon, Mr. Chair and members of the board. For the record, my name is Mahsa Vetandus with the subdivision section. Item number 5 on the agenda is the preliminary plan of subdivision for Morton Farm, case number 4-22067. The subject project proposes 140 lots and 5 parcels for residential development consisting of 140 single-family detached dwelling units. As can be seen on this aerial view, the site is surrounded by residential zone land developed with single-family homes. The site is bound to the west by Livingstone Road. This preliminary plan is associated with an approved Certificate of Adequacy ADQ-2022-084, which was approved in accordance with the subdivision regulations to ensure that infrastructure necessary to support the proposed development is adequate in accordance with established level of service standards. Before I continue, as a matter of housekeeping, prior to the noon deadline on March 10th, 2026, 7 items from the applicant's attorney, Mr. Gibbs, and 6 emails and 1 letter from citizens were received. These materials have been provided as additional materials dated March 3rd, 2026 and March 10th, 2026 for this preliminary plan, and all of which will be discussed further in my presentation. Next slide, please. This site is located in the southwestern part of Prince George's County within the planning area 83 and Council District 9. Next slide, please. More specifically, the site outlined here in red is located on the southeast side of Livingstone Road, immediately east of its intersection with Acco Creek Road West. Next slide, please. The zoning map shows that the site is currently zoned residential rural as shown in the image to the right. However, this preliminary plan of subdivision was accepted for review under the prior zoning ordinance and subdivision regulations, and under the prior zoning ordinance, this site was also in RR zone as shown in the image to the left. Next slide, please. This site map shows the site outlined in purple and indicates the topography on the site. Next slide, please. The master plan right-of-way map shows that the property has frontage on the master plan roadway Livingstone Road, which is classified as a collector roadway. Next slide, please. This photo shows another view of the site from an aerial perspective. The property is bound to the northeast and east by vacant wooded land and MNC PPC owned Acco Creek Park. The eastern portion of the property is currently improved with 2 single-family detached dwellings and several accessory structures, and the western portion is currently used for agriculture. All existing structures on the property are proposed to be raised. Next slide, please. This slide shows the proposed lots and parcels with the property boundary outlined in red, and the existing public rights-of-way adjoining the property in purple, and the proposed public rights-of-way in light blue. Also, the primary management area, or PMA, is highlighted in pink. The proposed development will provide 2 access points along Livingstone Road, and the public streets are proposed to be extended into the property to provide frontage and access to the proposed lots. This application is for a public benefit conservation subdivision, which proposed to cluster lots in smaller size than typically allowed in the RR zone in exchange for conserving more area of the site than would normally be required, but no more density is required. The site includes significant archaeological resources which are targeted for conservation. The preliminary plan proposes to subdivide the property into 5 parcels and 140 single-family detached lots with lot sizes ranging from the required minimum 6,500 square feet to over 19,000 square feet. One of the 5 parcels are proposed as conservation parcel to be conveyed to the Piscataway Indian Nation LLC, and the remaining 4 parcels are proposed to be conveyed to homeowner association. A conservation subdivision easement to the benefit of a non-profit land conservation organization will be recorded over a 39.34 acre area of the site, which is shown here green on this slide. The applicant proposes a trail connection from Aquatic Park following along the perimeter of the developed lots to Teresa Drive, the southern portion of the site. The proposed trail provides access to active and passive outdoor amenities for future residents and their visitors. Next slide, please. This slide shows a conventional lot layout for the property if it was developed based upon conventional RR zone requirements. The layout and proposed road construction will result in substantial impacts to the on-site environmental and archaeological features. The conventional layout also shows a reduced conservation area highlighted on this slide green compared to the proposed conservation or proposed with the preliminary plan of subdivision. In conventional development, the lots are also larger, thus associated with expanded areas of disturbance, clearing of woodland, and removal of specimen trees. Next slide, please. This slide shows the Type 1 tree conservation plan with the proposed on-site woodland preservation, reforestation areas highlighted in green and natural regeneration in yellow. The woodland conservation requirement is proposed to be met through on-site preservation, reforestation, and regeneration. The applicant has requested a variance from section 25-122B1G, which requires preservation of specimen trees. This preliminary plan of subdivision proposes removal of specimen trees on the site, and the location of which are shown by green circles and red cross on this slide, and are located within the area identified for development. This variance request is supported by required findings for approval and discussed further in the environmental findings on pages 24 to 27 of the technical staff report. Next slide, please. This slide shows the conservation area proposed as 39.34 acres or 47% of the site, which exceeds the minimum requirement of 33.81 acres or 40% of the site as required for a conservation subdivision. Next slide, please. As mentioned at the beginning of my presentation, staff received 6 emails submitted by citizens, Ms. Penelope Breeze, Candice Bigelow, Carol Donahoe, which are provided as additional backup materials for this preliminary plan. In all these letters, citizens expressed concerns regarding traffic safety, of traffic on adjoining roads, and public safety. As mentioned before, the certificate of adequacy for this case was approved in accordance with section 24-4503 and is not before the planning board for consideration today. The proposed development was evaluated for traffic impacts and transportation adequacy, and all of which meet the level of service standards. A letter from Mr. Greg Smith was received requesting denial of the Mordon Farm preliminary plan of subdivision, citing concerns that the late posting of the staff report and supporting backup materials undermined transparency and limited informed public comment. This case was continued from the March 5th hearing in order to finalize some details and the final recommendations of the preliminary plan published on Friday, March 2026 in accordance with the regulations. In addition, 7 items are received by the applicant's attorney, Mr. Gibbs, including first, revisions to condition 2B, 3E, 5 and propose revisions to the findings on page 8 of the technical staff report. Staff is in agreement with the applicant's revision to conditions 5 and the revision to the finding on page 8. However, staff is not in the agreement with the proposed language for condition 2B and 3E. Second, a summary report of the applicant's community outreach efforts, which I believe will be further presented by Mr. Gibbs. Third, the conventional layout exhibit. Fourth, the traffic impact study for the project and the State Highway Administration's review comment, which have been incorporated in the findings and conditions of the preliminary plan. Fifth, the resumes of the applicant's senior stormwater management engineer and traffic consultant for this application. In conclusion, the subdivision staff recommends that the planning board adopt the findings and approve the preliminary plan of subdivision 4-22067 Type 1-3 Conservation Plan TCP 1-2025-0030, as well as the variance request from section 25-122B1G for removal of the specimen trees subject to the conditions included in the technical staff report as amended in accordance with the applicant's proposed language to finding on page 8 and the proposed revisions to condition 5. This concludes the staff's presentation. Thank you.
Outstanding job as always. I know we started late, but unfortunately, we're going to take a 15-minute break. We're having some technical difficulties. The time is now 1:48. We will now hear from the applicant's attorney, Mr. Gibbs.
Good afternoon, Mr. Chairman and members of the Planning Board. Thank you for this opportunity. My name is Edward Gibbs, and I am an attorney in Georges County. My office is located just down the street on Caraway Court. And I am pleased to be here this afternoon representing Caruso Land Development, LLC, and that is an entity controlled by Caruso Homes, a builder and developer with extensive experience up and down the East Coast, but with a major presence in Maryland and in particular in Prince George's County over the years. And I have been pleased to be able to represent that company during many of their efforts here in Prince George's County, and I can attest to their desire to do things the right way and to also conduct the outreach that's necessary for all cases. I'd like to identify here with me today Mr. Peter Pomponio, Mr. Jamie Atkinson, both of Caruso Homes. We also have members of our team here. We have Mr. Michael Lenhart of Lenhart Traffic Consulting. We have Mr. Phil Hughes of CPJ, the civil engineering firm on this project. And we have Mr. Patrick Walters of Applied Archaeology. And Mr. Walters and his firm did the archaeological study, which is really at the center of this case that you're going to hear about today. And I have so much that I could say. I'm not going to say it all my first time up here. I'm going to see what else I have to respond to. But a couple things I want to say at the outset. This case was originally scheduled to go before the planning board back in December. I asked for a long continuance to try to conduct major and more extensive community outreach. I have worked with staff. I can tell you that the project now is substantially better than it would have been initially as a result of the time and effort that your staff has taken to analyze this case in detail and to be willing to listen to the concerns and comments that we had to make. And at the end of the day, it's a better project. And I can't say enough about how enjoyable it's been to work with the staff in a complicated case like this and try to achieve solutions and resolutions. I'm going to talk a little bit about our community outreach because it's important, but we have worked tirelessly with the Piscataway Indian Nation. And some of the changes that we have requested to the conditions, by and large, we adopt the staff report because we agree with the staff's analysis. We had a couple of exceptions that we wanted to discuss with regard to the conditions in the staff report. And, I appreciate staff's comments about agreeing with two of the conditions that we wanted to revise. They couldn't agree on 2B. Now, we're going to talk a little bit about the archaeological study that we did, but there are artifacts on this property. And some of those artifacts, you're going to hear from our archaeologists, they did over 1,200 shovel test pits every 50 feet across the entirety of this site. And they uncovered some artifacts already. There are two types of artifacts that we have on this property. We have colonial artifacts, which are old to us, but not that old. And then we have archaic and pre-archaic, going back 6,000 to 7,000 years. And they are directly related to the Piscataway Indian Nation. Those are, not the colonial artifacts. So when I wrote this, when I looked at condition 2B, it says take the artifacts and send them down to St. Leonard. And I know from working with the Piscataway Indian Nation on this case that once artifacts get in the hands of the government, it's really hard to get them back. And they are stewards of this property. They have a keen and sincere interest in the property. And so I wanted to revise the condition to just say that the artifacts should go to the Piscataway Indian Nation and not down to some curated facility run by the state in St. Leonard because of the difficulty that they've experienced in trying to retrieve items once they get into the hands of the government. And so I had asked to revise the condition to just say, let's just give those artifacts to the Indian Nation right now. It's their ancestors who left them on the property. And I did make a mistake here because I should have said the archaic and pre-archaic artifacts, not the colonial artifacts. So while staff says they can't agree with this condition, I would amend it to say the archaic and pre-archaic artifacts, not the colonial artifacts. But from my client's perspective, we still think those artifacts should go directly to the Piscataway Indian Nation, the entity that we've been working with to actually take title to the conservation area on this property. On 3E3, I'll retract that request for a change because when I filed this letter, it was my understanding that we were going to be trying to get the entire, there's a trail, 10-foot wide trail that's going to run from the Accokeek Park on the north all the way down through this subdivision on the rear of the lots, the lotting pattern. And I had thought we were going to keep the trail out of the conservation area, but it's impossible to avoid at least at the start of the trail. And so to that extent, my request for deletion of 3E3 is not appropriate because you can't avoid that little piece of the trail not hitting the conservation area. And so I understand staff's concern there. The other two changes staff had agreed with, in particular, the finding in condition 8 relative to the tax exempt 501c3 entity to be part of the conservation easement that has to be created. There's the ownership of the conservation parcel, and then there's the conservation easement. And when it's a non-governmental entity involved, a private entity, so to speak, there has to be another entity that's part of the easement that is separate legally from the entity that holds title. And the change to our finding number, our finding on page 8, that's at the back of my letter to you, Chairman Barnes. We would like to have that inserted as a revision to the existing finding on page 8. And I believe staff has agreed with that. And so we're very thankful and appreciate it. Let me just say, you know, I'll come back up because I know there are some folks that are still signed up in opposition here. And there may be some things we'll have to come back up and rebut. But I do want to talk a little bit about community outreach here. As I mentioned, this case was originally scheduled to go before you in December, I think December 18th of 2025. And I filed a letter request asking for a continuance so that we could have more extensive community and citizen outreach in anticipation of coming before you. And so I filed that continuance request. And when I filed that request, I also filed and mailed a letter to all parties of record at the time and everyone who was on the acceptance mailing list, letting them know that I was requesting that continuance. And the case was continued until March 5th. And the reason it was continued for so long is because one of the associations we needed to meet with, Greater Accokeek Civic Association, they weren't going to have a meeting until the very end of February. I think it was February 27th, if I'm not mistaken. And so that's why we had to push it out so far. But we filed that letter and we appreciated the planning board giving us that extra time because we needed it in the outreach. And in addition to the witnesses, the consulting witnesses who identified, I have with me Mr. Stephen Proctor of GS Proctor Associates, because my client brought them on board and asked for their help in making sure that our community outreach was comprehensive in nature in this case, because there was a lot of interest in the project and a lot of interest just in generally down in Accokeek. And so we went ahead and basically GS Proctor and Associates coordinated the community outreach. And, you know, both myself and representatives of GS Proctor received lots of inquiries, individual inquiries, not just from organizations. And we were putting all that information together. And so GS Proctor prepared a community outreach summary, which I entered into the record. And I wanted you to know that Mr. Proctor is here to authenticate that, should it be necessary. He did sign up to testify. If you don't feel it's necessary for him to testify, that's fine, but he is here and available to do that, to verify that everything that's on this sheet did in fact occur. And so what I want to point out is this. We would receive phone calls, and it would be either myself or it would be someone from Mr. Proctor's office, and we would forward information directly as a result of phone calls that we received. But in addition to that, we wanted to have some comprehensive citizen outreach. And so the first of them was to contact the Accokeek Development Review District Commission. And I see that Mr. Sullivan McElvain has signed up on the remote today. But we met with them on December 17th of 2025. And we made a presentation to that group. We explained everything about the project. We took questions. We answered questions. We provided information. Then our next so-called group outreach effort occurred on January 14th of 2026. And that one was, we took all the calls that we had and people that we had addresses or email addresses to, and we said, we're going to invite all those people to come to a meeting at the Accokeek Library, which is what we did. And that occurred on January 14th of 2026. we had at least 60 people in attendance at that meeting. We answered questions. We stayed there until there were no other questions, and explained in detail the project and why it was proceeding in the manner that it was. Our next large group meeting was February 26th, not the 27th, and that was delayed again because the Greater Acteague Community Association wasn't meeting until that date. And there were a lot of people there, but the number here is 50 that GS Proctor put on the list, and that was held at the Acteague Volunteer Fire Department. Once again, we answered a lot of questions. In all these meetings, we brought some of our consulting team. That night for the last meeting, we brought our traffic engineer, we brought our civil engineer, and we brought our archaeologists. And everyone was there to answer questions. And we stayed for quite a lot. We stayed beyond the time that the fire department had said we could stay, probably about 30, 40 minutes beyond that. So we have conducted extensive community outreach. We've tried to address folks' questions. We've tried to do things as a result of concerns that were raised. We couldn't satisfy everybody. Some folks just don't want anything to happen. But for the groups that we met, to have 60 people and 50 people and 30 people, and today there are some people here signed up, but there aren't 50 people signed up. We have worked hard and we've tried to do a good job to communicate and to explain our position and to address concerns. I want to say that at the second meeting that we had, representatives of the Piscataway Indian Nation were present, in particular Chief Tyak and Mr. Apache. And they indicated that they wanted to have a separate meeting with us. And we had that meeting, and we have had incredibly extensive dialogues with them. Because for them, this property is sacred. The archaic and pre-archaic artifacts that have been discovered already in the test shovel pits and which remain buried on the 33 acres that we're setting aside, those are relics from their heritage. And so initially, when we went forward, this conservation area was going to be deeded to the Park and Planning Commission. That was the request that was made. But when the Piscataway Indian Nation came to us and said, we think that should go to us. And there were folks, non-tribal individuals in citizen meetings that we had that also said to us, we think that land should be deeded to Piscataway Indian Nation, not to the Park and Planning Commission. So I went, and my client supported this 100% and started a dialogue with the Park and Planning Commission. And I must say, everyone at Park and Planning, as soon as we put all the information out there, and that includes not just development review, historic preservation, Parks Department, everybody agreed that was the right thing to do. And so staff modified their position to allow us to deed the 33-acre conservation parcel to the Piscataway Indian Nation, LLC. They also are going to create a separate 501c3 entity to fulfill the mandate to be the third party on the conservation easement as mandated by section 24-152-0 of the prior subdivision regulations. That separate legal independent entity that's going to be set up for the sole purpose of monitoring under the conservation easement to make sure that everything stays in perfect condition on that property. And who better to do that than two entities, separate, legally distinct, but both representing interests of the Piscataway Indian Nation. We personally applaud that effort and support it 100%, and we can't say how much we appreciate the staff commitment to go in that direction with us and to make those revisions to the staff report. So that's where we are with regard to community outreach. And I want to say a few words about the process itself. we started down this road back in 2023. And to their credit, Crusoe Land Development, Crusoe Homes, they put this property under contract. There are 5 parcels. They actually own 1, but it's just an acre. It's just an acre. The other 4 parcels are owned by the Morton family. And in total, it's 85 acres and some change. And so originally the plan was to just do, it's zoned RR, 20,000 square foot lots, 85 acres. Let's do a conventional RR subdivision and go down the road. But my client knew about the cultural and historic significance of land in the Accokeek area. And so they went ahead and they went out and retained the services of applied archaeology. Mr. Patrick Walters is here today, and I'm going to ask him to say a few words. And they had that company go out and do a phase 1 archaeological study and analysis of the entire 85 acres. So Mr. Walters and his firm went out there with a lot of folks, and they did those 1,200 and some odd test shovel pits across the entire 85 acres of the property. And what they found is that there were 2 sites that should be identified, Site 1252 and Site 1253. And 1252 is in the east and northeast section of the property. And it's really about 15 and a half acres. And then 1523 is, 1253 is more over the area where the lots will be. But their findings were that that area had been degraded and impacted by agricultural practices over the years, and the artifacts that you could find there, it just wasn't a quote unquote pure situation. So the area to be protected was the area to the north and the east, and in total, even though it was only 15 plus acres, where the extensive historical site qualifying to be on the National Historic Register, we took 33 acres and carved it out and said, that's going to be untouched and it's going to become a conservation parcel. And that leads me to the next step in the process that we had. And that was, okay, so we shared all this information with historic preservation, and I can't say enough about the help and the guidance that they provided, but we were encouraged and we knew about the conservation subdivision process. Not a lot of them have gone through here in Prince George's County. Actually, Crusoe Home did one in the northern part of the county. It's called Pecan Ridge. And Commissioner Geraldo, you may remember it because it wasn't that long ago. But we said, okay, we're going to do a public benefit conservation subdivision. And the whole concept is that when you have something special about your property, whether it's a cultural resource, an historic resource, the code is very clear about what qualifies. It's important to preserve that for the future, for future residents, for current residents, for history purposes. And you don't get to increase your density, but what you do is you carve out and you preserve that sacrosanct area. And then in return, you get to do a subdivision on the balance. It's all part of the same subdivision, but you get to do a subdivision where the lots are smaller. You can go down as in the RR zone as low as 6,500 square feet, as opposed to a traditional 20,000 square feet. We have very few lots that small. We have lots that are like 10, 12, 15,000 square feet. We have some that are like 19,000 square feet. But we were able to retrieve our density while still agreeing to be stewards of the land and preserve artifacts and preserved areas that should not be disturbed on that property. And so we filed a public benefit conservation subdivision. And that's what we're here on today. And again, that brought us into working with the Piscataway Indian Nation. And as a result of our meetings with them, brought us to the point where we said we want that 33 acres to be deeded to the Piscataway Indian Nation, and staff has now agreed. And that's the direction we're heading in. In all of the public benefit conservation criteria are contained in Section 24-152 of the prior subdivision regulations. And we used the prior subdivision regulations because we started out this process using the prior regulations. Because if you're going to go with a conservation subdivision, you have to first do a sketch plan. And that sketch plan gets referred out to various agencies, and ultimately the planning director makes a determination of whether or not it can be certified to move forward. We did that. We started that in December of 2023, I believe. It took over a year to get through that process. It was approved, maybe not quite a year, because we filed it in December of 2023, but we started it well before then. It was certified by the planning director in July of 2024. And that then led us to where we could then proceed to actually prepare and file the preliminary subdivision plan itself. And under that, you had to conform to not just 24-152, but also 24-119, which are the general criteria governing preliminary subdivision plans. And that, of course, brings you into adequacy of transportation facilities, DPI involvement, civil engineers figuring out where NRI, stormwater management plans, et cetera, et cetera. We've been through that process. I have Mr. Lenhart here today. He did a transportation analysis, and I'm going to give you a real quick summary of it. And if he needs to come up as a rebuttal witness, I'm going to ask him to come up. But here's what he did. He followed strict protocol. He met with transportation staff. They developed an agreed upon schedule of what he had to do, a scoping agreement. They said, we want you to look at, I think it was 6 intersections. We want you to take traffic counts of existing traffic and put those in there. Give us what the levels of service are. We want you to do, I think it was a 1% annual growth rate, just because. And then we want you to add in the traffic that will be generated by your 140 lots. They did all that. Every intersection passed with the exception of the intersection of Indian Head Highway and Livingston Road. It passed in the morning and it failed in the PM peak hour, So under the transportation adequacy statute that you have now, when you have a failing intersection, you can do mitigation. And mitigation means you have to do something that will address 150% of the traffic your project generates. So it will mitigate your 100% plus another 50%. That's the test. That's the law. So Mr. Lenhart identified changes that could be made by the right-of-way width on the west side of Indian Head Highway at Livingston Road. It's limited in the right-of-way width. But what he was able to do was reconfigure the lanes and then recommend a total phasing change to the traffic light. And that generated 287% mitigation. So well over what we were required to do. Now, it just wasn't him saying that. He submitted that document to the Transportation Planning Division. They agreed with the findings here, and it was submitted to the Maryland State Highway Administration. They agreed with the findings, and their letter of approval and support for that study is in the record. But I put another copy in just the other day, as well as a copy of the revised traffic study, because when we were meeting with the neighbors, they said, well, we want you to also look at traffic from the post office that's right across Livingston Road from the site. And we want you to look at these 2 driveways that are right where you turn right on Livingston Road when you're coming south on 210, because there are 2 commercial uses that have driveways right into Livingston Road close to the light. And so Mr. Lenhart did all that. He actually put up cameras down there very recently to observe how those driveways are working. And he did this revised report. So the report that I put into the record, he had already put it in, but I wanted to make sure everybody had it. It's dated February 26th of 2026, along with the State Highway Administration letter supporting the findings. So I want to say that we have abided by the not just the letter, but the spirit of all the regulations and statutes. We even went above and beyond. We went to the other side of Indian Head Highway where Livingston Road comes in from the east. And we said, you know what? There's enough right of way there. Why don't we, above and beyond what we're required to do to address concerns, let's put in an extended right turn lane. That helps how the whole intersection operates. We proposed that at our last meeting with the citizens. We were told they didn't want it because they didn't want the green area, the grass that it would take up to put that 12 feet of paving in to go away. So, okay, we said, we won't do it then. But that was something that we proffered that wasn't even required. Just trying to make things better. So I would say that we agree with the staff report. We meet all the criteria in 24-152 related to conservation subdivisions. We meet all the criteria in 24-119 relative to just subdivisions in general. And in particular, we want to reiterate that we stand in solidarity with the Piscataway Indian Nation. I know they're on board virtually here today, and I think they're going to give some testimony. But we have certainly supported them. We will continue to support the efforts to preserve this area with them, and we look forward to their comments here today. So with that being said, I would like to ask Mr. Patrick Walters to come up and just very briefly give you an overview of what he did for the archaeological study. And then we're going to stand down and let other folks testify. And if we have to come back up, we'll be happy to do so. Thank you very much.
Hi, my name is Patrick Walters. I'm the Director of Cultural Resources for Applied Archaeology and History Associates.
Second.
Sorry for witnesses, we need everybody to be sworn in.
Sure.
Anybody else who's wishing to speak and testify in this matter, if you could stand up, please, and raise your right hand. And everyone online? Swear to tell the truth, the whole truth, and nothing but the truth.
Do.
Okay.
So yes, my name is Patrick Walters. I'm the Director of Cultural Resources. I'm an archaeologist with Applied Archaeology and History Associates. AHA is a company that was started founded by Jeannie Ward, our president, in 1998. Since that time, she has led teams that have conducted thousands of archaeological and other cultural resources studies throughout the Mid-Atlantic region. Morton Farms is one of them. We were contracted by Caruso Homes in 2023 to conduct the Phase 1 archaeological survey. As he mentioned, we actually excavated just about 1,300 SCPs at 15-meter or 50-foot intervals. All of this was conducted in compliance with and actually above those guidelines provided by the Maryland Historical Trust, which is also what the MNCPPC staff does as well for historic preservation. And also the National Park Service, the criteria for National Register listing eligibility. There are 4 criteria. As a result of that study, the 1,300 SCPs, we've recovered a little over 1,200 artifacts, specifically from 2 sites, as he mentioned, Site 1252 and 1253. At Site 1252, it was apparent pretty early on in our analysis that we were recovering archaic period pre-contact artifacts from deeply buried captain sealed horizons, that basically means that deeper in the soil column below where the agricultural plow zone would be, we were getting exclusively pre-contact artifacts from that archaic period, which would be about 11,500 to about 3,500 years ago. And it was exclusively those artifacts from those horizons, which when we identify that, we know that those deposits have integrity of deposits and significance. Therefore, we recommended that site as potentially eligible for listing on the National Register of Historic Places as per the guidelines and as per the National Park Service guidelines as well. And for avoidance or for Phase 2 evaluation, as we've seen now, there's a conservation easement placed on it, and if the site was avoided, which is a very good outcome for us as archaeologists, we would prefer avoidance and preservation in place. For Site 1253, we recovered about half the number of artifacts we did in Site 1252 over a much larger area. It was scattered over a larger area, and almost all the artifacts we recovered in Site 1253 were from plow zone contexts, meaning they were, and we also intermixed. We did find a small number. We only found 10 pre-contact artifacts and a little over 250 historic period and modern refuse, all mixed into the same context in the plow zone. Now, according to best practices and what we normally do, we've applied this again to thousands of investigations, not just our company, but many companies that do cultural resources. And so we, as a result of that, we recommended that that particular site, just based on the fact that there was no integrity and not a lot of significance, it was not eligible for listing and for no further work. That's a common outcome for many of our investigations. We submitted the report to our client submitted it to the staff, and the staff concurred with our recommendations. That's it. That's pretty much the long and short of what we did and how we're involved. Happy to answer any questions.
Yeah, I have a couple of questions. Sure. You uncovered roughly 1,800 pieces of artifacts.
I think about 1,200, I think.
So you said 1,200 the first site, and another.
No, sorry, I'm sorry. It was about 600 in the first site, 500 in the other site, and then about 100 from isolated finds like that, about 1,200.
Okay, so you uncovered roughly 1,200, 1,100 pieces of artifacts. What did you do with them?
They were brought back to our lab. They were washed, cataloged, and we conducted analysis on all the artifacts as per the guidelines. And then they were cleaned, rebagged, and prepared for final curation, wherever that might be. They are currently in cold storage at our lab at this point.
So typically, what role does the State Historical Preservation play?
In this particular case, we were conducting this in accordance with a request from MNC-PPC, not specifically the state, with the Maryland Historical Trust. However, MNC-PPC uses the MHT guidelines as well for investigations. I have no knowledge of MHT's opinion, or because they were not part of this process. It was
typically, doesn't the State Historical Preservation receive those pieces of artifacts?
We recommend that, so for final curation, we recommend that those artifacts.
You would recommend that those pieces go to the state?
Go to the state, to the MAC, what we call the MAC lab, the Maryland Archaeological Conservation Lab. It's a curation facility. However, in the end, the artifacts do belong to the landowner first. They have right of first refusal. That's the law. So, but we are holding them right now in cold storage as this is being negotiated, and we return them to whoever makes that final request.
Okay, thank you. Are there any other questions?
I have none.
All right.
Yes, Mr. Chairman, that we're going to stop at this point, and happy to answer any other questions you may have, but reserve the right to come back on rebuttal if that should be necessary.
So,
Thanks, sir.
I believe that there are several that have signed up to speak. Please bear with me on name pronunciations, as I am not as fluent as Commissioner Poirier. But I will start with Ira Apache from the Piscataway Indian Nation. Is Mark Tanya. Valerie Hall. How about Greg Smith?
This is Ralph Apache from the Piscataway Indian Nation. Our chief is here, Chief Mark Tayak, and both myself and Valerie Hall would like to see any time given to us to our chief to speak. However, the chief would like, if possible, if the chief would like to hear the other comments from the community before he speaks, if that's okay. So he would like to speak last, if that's okay.
Mr. Apache, you can begin. You have 2 minutes.
Did you hear what I just said?
Yeah, I'm sorry. Your chief can speak.
You want to speak last?
Or he wants to speak last.
Yes. Yes, if you don't mind, if he could speak last.
Looks like the chief is last first. Valerie Hall. Mark Tayak.
Chief. He's the chief.
That is Chief Hayek.
Begin.
Yeah, again, if the chief could speak after everyone else speaks, after everyone else who signed up.
After
So
everybody.
both me and Valerie Hall would like to convey our time to him.
Okay. Brian Hargis. Jess Dabrowski. Catherine Lucas.
Yes, sir. I'm here.
Yes, ma'am. You have 2 minutes.
Thank you. Good afternoon, Mr. Chair, members of the board. My name is Catherine Lucas. I'm the fire chief at the Acton Volunteer Fire Department. I appreciate you letting us speak today. On behalf of our department, we are opposed to this development for 3 specific reasons. First, Livingston Road, which this portion of Livingston Road from the 15,800 block to the 18,100 block. Currently, there are approximately 100 homes that currently sit on that portion of Livingston Road with a direct right-of-way. Adding this subdivision would add, they stated, an additional 140 homes that would have to have direct access to that road. This would increase the traffic, in both for vehicular traffic and for pedestrian traffic. We feel the road is already in poor condition. I can attest to this. We had a fire truck that was severely damaged years ago and actually bent the frame because of the poor condition of that roadway. Additional traffic would, we feel, will cause additional damage to both our fire trucks, and it's not a good road, we feel, for additional 140 houses worth of traffic. Second point we have was the hospitals. Primarily, historically in our area, we had 4 primary hospitals that we went to: Fort Washington Hospital, Southern Maryland Hospital, and Charles Regional Medical Center. We also used to have United Medical Center. That recently closed, which caused a 25% reduction in our available hospitals for the region, but for our immediate area, which is our close transport distances. So additional 140 houses restricts, adds additional burden to emergency services and for hospital capacity, which is already reduced. Our final point that we bring up is safety, where the fire department safety is our #1 priority. Additional houses, especially on that portion of Livingston Road, adds more pedestrians. Those of you who live in the area have seen an increase in pedestrian traffic on the roadway. Less than 6 months ago, we had a pedestrian that was struck and killed in this immediate vicinity, and we take that to heart. I've lived here my entire life, and we never want to see any of our members, any of our citizens get injured. So we have to feel that there's a need for increasing the infrastructure before adding more houses. So I leave you with just one question for you and the board. My question is, how many residents have to die in our community before we put safety over money? So for us, we feel that one death of one resident is too many. And so for that primary reason, we are opposed to this development. We support our rural community and we support the Piscataway Nation. So thank you, sir, and appreciate your time.
Thank you. Ms. Lucas, have you spoken with the Prince George's County Police Fire Department?
I speak with them quite regularly, yes. Typically for local community matters, they do have a portion that I know that all the planning processes go through. I can't recall exactly which office they go through for approval of site developments and stuff like that. However, we still have the right to speak for our local community that we serve. So yes, the fire department, Prince George's County, they will look at the applications, and yes, does it meet the fire department requirements for a response? Yes and no. And if it doesn't, such as roadway distances and things like that, they will have their input. But for local impacts, we speak on behalf of that. Again, just because we are here, we understand our community, and we try to have very good interaction with our local citizens and our keep our thumb to the pulse of our neighborhood.
And I can appreciate that. And I wish, you all were on the same page, because the the Prince George's County Fire Department has a different opinion than yours, but I wanted to make sure that you had the opportunity to voice your concerns and opinions as well.
Yes, sir. Thank you so much. I appreciate that.
Yes, ma'am. Is Sam Ayana or Anya? Sam? Emily Cavanna?
Canavan. My name is Emily Canavan. I speak on behalf of myself and on the Accokeek, Mattawoman, Piscataway Creeks Council. I think everybody noticed all those names that were called and people not answering, and that is because
I don't want to interrupt you. I apologize, but we do need to clarify if you're speaking on behalf of yourself or an organization.
Oh.
So you're
president of that organization.
speaking on behalf of the organization?
I'm also a resident. I live within 5 miles of this site.
Okay.
All these names that were called and people not here to testify, it's 2:30 and most people found out about this meeting last night or today. After repeatedly and confusingly changing the dates, the venues, the methods of this hearing, we heard about these continuances November 18th, December 18th, February 26th, March 5th. Last week I was told it was only going to be virtual, and then suddenly it was this week. And it is a Thursday afternoon in the middle of the day. So I think the point about how the community hasn't shown up like they did at these other meetings is a very poor point, because I don't think that the community was given the respectful, they purposely said signs were posted on November 18th, so we don't have to post them again. It is now March. It is insane to think that a posting in November is sufficient. It's not. I would also like to say that using the Microsoft Teams link, I have just in this hearing gotten emails from several people saying that it didn't work. They don't know how to use it. It seems like that is leaving out a part of our community who may not be very familiar with current technology, but still have concerns about their community. I just wanted to state that. And then what I also want to say is the 140-day mandatory action time frame, I think, and I would like to request formally that it be restarted today, because there is a great deal of information that was not available at that time. The archaeological study, folks were trying to get a hold of that for many months. I finally got a hold of it in January, but it is not my job to spread that out amongst the community. That should be on the staff. Last week, the technical staff report was expanded from 2 pages to 51 pages. So people have not had a chance to digest that and give feedback on that. In March, the backup file was taken from 2 pages to 255 pages. I was at the meeting when the Piscataway Nation first came in January.
You're 2 minutes, so if you'd like to summarize, please.
Okay, I would just like to summarize that this is not the building of a hospital, and to say that the rules about taking out specimen trees and high density all should be set aside because this person has asked seems very unfair. And if any other citizen in this county wanted to do the things that they are doing, they would not be allowed. This community has spoken out. I've been at all of these meetings, 50, 60 people showing up without any notice, and all of them saying, this is not what we want in our community. We don't want more traffic. We want to have adequate public facilities, and Livingston Road is a train wreck. What Ms. Fortgang said is correct. It is dangerous to drive on. Adding all of these cars is insanity.
Thank you so much. I believe that there are no others signed up in opposition. We will now hear back from this. Oh, the chief, I'm sorry. Mr. Apache. Mr. Tyak?
Yes. Yes. Can you hear us clearly?
Yes. Yes.
Okay, thank you.
Before you go,
like
Chief, Chief, before you go, Mr. Greg Smith is just all dead. All dead. He just came on. Mr. Smith? You're on mute, Mr. Smith. Mr. Smith, you want to log out and log back in? I'll give you a minute. Yes, ma'am.
I wanted to mention Mr. Stevenson, who was mentioned earlier from the Act Peak Development Review Commission, sent me a message saying that his audio isn't working, but he's also signed up to speak.
Rick Smith is back. Mr. Smith. Where'd he go? Just there. There it is. Mr. Smith? Is there a number they can call in?
Yeah, I'm going to put it in the chat.
All right. Mr. Smith, we're going to put a number in the chat that you can call us. Keep your camera on them. In the chat.
Numbers in the chat.
The number's in the chat, Mr. Smith. All right.
Somebody's waiting to be.
Mr. Smith?
Can you hear me now?
Yes, sir. You have 2 minutes.
Yeah, unfortunately, we got an echo. Mr. Chair, I have to protest. This meeting has been continued twice, and I logged in at the meeting for a hearing. It commenced at 2 o'clock. The purpose of this hearing is to create a full evidentiary record, not to keep people to 2 minutes. And the applicant was allowed to speak for well over 20 minutes. While I support conveyance of sacred lands and artifacts of Piscataway,
Yeah, I think we,
Not to use a speakerphone.
yeah, Mr. Smith, if you can go ahead and log off and just call in, we should be able to pick you up.
But not on the speakerphone. That's a problem with feedback.
We can't hear you.
Move on to Chief Tech.
All right, Mr. Smith, can you submit written?
No, but
No.
we can hear from Chief Kayak and then hopefully he fixes his problem.
Yeah, Mr. Smith, we're gonna hear from the next speaker, then we'll come back to you. Hopefully we can get it worked out. Chief Tack.
Okay, can you hear us well?
Hear you well.
First of all, my name is Chief Mark Tyak. I am the 29th generation of hereditary chiefs of the Piscataway Indian Nation. My father, his name was Chief Billy Redwing Tyak, the 28th generation of hereditary chiefs. My grandfather was Chief Turkey Tyak, the 27th generation of hereditary chiefs, who also, in 1979, the United States Congress passed a federal bill granting him the permission to be buried within the boundaries of Piscataway National Park. My great-grandfather, Woza Tyak, the 26th generation of hereditary chiefs of the Piscataway Indian Nation. The land here in question is part of what was known as the principal capital village known as Mayone, which extended up to the Woodrow Wilson Bridge north of the area, all the way down to Indian Head, south of the area. It's been documented that our people had a continuous presence living on the land known as the principal capital village for 15,000 years. For 15,000 years, this principal capital village was equivalent, and still today, like Washington, D.C., being the capital of the United States. I've heard today about the sensitivity of the whole site. The sensitivity I witnessed personally myself. If we go back a little bit in time, in 1976, there was a blockhouse where our ancestral remains of an ossuary of a burial site was dug up, put on public display as a form of tourism. And I actually now am very happy and excited to be in conversation and dialogue with Caruso Homes. No offense to anyone, no offense. Every inch of our land was stolen. Every inch of land stolen. We had treaties. That whole area was to be known as the Mayone Reserve, the Mayone Reservation. No individual in the Accokeek area has ever offered the Piscataway Indian Nation 1 inch of land. Prince George's County has never offered 1 inch of land.
Mr.
The state
Tyak,
of Maryland has never offered 1 inch of land.
Mr. Tyak, I gave you an extra minute.
Two people cede their time to him.
I have
You can't
Mr.
concede your
Patrick's
time. You can't concede time here. So I'm gonna ask you to
to wrap it up.
Statement.
We are currently in the negotiations with Prince George's County and Caruso Homes so that we can have a footprint in our homeland. So we are supporting Prince George's County, Caruso Homes, and we hope that the residents will support the Piscataway Indian Nation. Thank you.
Thank you, sir. Thank you, sir. Mr. Smith. Greg Smith. Seems like we're going to have to miss Mr. Smith. We will now hear back from Mr. Gibbs.
Mr. Chairman, just ever so briefly, I'd like Mr. Lenhart to come up and address this issue relative to the fire department, please. Thank you.
Mr. Lenhart, could you also, for purposes of the residents that are on, can you explain precisely the mitigations that you propose that increase the viability of the development?
Yes, sir. So for the record, Michael Lenhart with Lenhart Traffic Consulting. The intersection of 210 at Livingston Road, currently as you drive eastbound on Livingston Road, it's a 3-lane approach, a left turn lane, a through lane, and a shared through right lane. Westbound is a left turn lane, a through lane, and a right turn lane. And the signal is, it's concurrent. So when you're on Livingston Road and you're going east or west, you have green signals at the same time for eastbound and westbound traffic. What we've proposed is to split phase the intersection. So east and west would be green at different times, and then restripe the intersection. So eastbound would be a left, a shared left through, and a shared through right. The change being the center lane would be changed to a left and a through. That would allow for a double left turn to go north or to go eastbound to northbound. That's one of the predominant movements for that leg. And by making that a double left, that allows more traffic to move through in the same amount of time, reduces the amount of green that's needed for that leg. And then on the westbound side, it would be changed to a left, a shared left through, and a right. So the predominant movement there in the evening is a left turn to go south on 210. And so today there's a single left. We would provide a double left. Again, it moves more traffic through the intersection, allowing more time back on Route 210.
So where you're proposing that 2 lanes for the left, that's on the side where the shopping center is. And there's a gas station there as well?
There's a gas station on the east side and the shopping center on the east side, on the north of Livingston. The west side, north of Livingston, there's also a small gas station there, but
The carry out.
in the carry out, the B&J's carry out. Yeah.
Okay, thank you.
Yes, sir. I'd like to address the volunteer fire chief's comments. I think she had 3 comments. One, that it adds 140 units, and she was concerned about the additional units being added and the ability to service those. I'd like to point to pages 229 and 230 of the backup materials, which includes the information related to the certificate of adequacy. And per section 244509 of the subdivision regulations, the materials in the backup includes information from the department or Prince George's County Fire and EMS department stating in writing that this application passes the adequacy requirements of the subdivision regulations. Therefore, it does meet that adequacy requirement. The road condition was a second comment. I've driven it. I can agree. The road's not in great condition. There are some locations that need maintenance. Maintenance of county roads is a responsibility of Department of Public Works and Transportation. That's beyond anybody's purview. The county at some point, they're going to have to get out there and do a mill and overlay. But that's typical. Roads go through a cycle of degrading a bit and then having to go through a maintenance cycle. It's a typical process. Pedestrian safety along the roadway. I understand that comment. We can't fix the whole roadway, but there is a condition 4B of the staff report that requires a 5-foot sidewalk along our site frontage, unless modified in writing by the permitting agency. But we do have a condition that that's to be provided. So,
Thank you. Mr. Gibbs.
Yes. Thank you, Mr. Chairman, members of the board. We really don't have any further evidence to present in rebuttal. We do support the staff recommendation for approval of this preliminary subdivision plan. We think that approval is comporting with the overwhelming evidence which has been presented, not just here today, but in the record before we ever got here today. We meet or exceed all required criteria for the approval of this preliminary subdivision plan, and we look forward to continuing to work with the Piscataway Indian Nation and the Park and Planning Commission in the hope that this preliminary subdivision plan goes forward. Thank you very much.
Thank you.
We'd like to hear from the staff, if we can, with regards to the remains for Piscataway Nation, or the artifacts. We have a protocol. Doesn't the commission have a protocol?
Our archaeological expert is present with us now. May I ask her to join us for further information?
Amelia Chisholm, Archaeology Planner 2 with the Kennewick Planning Division. So our archaeology guidelines, which are part of Subtitle 24, say that all artifacts recovered are recommended to be sent to the Maryland Archaeological Conservation Laboratory in St. Leonard's, which is the state conservation facility. The guidelines suggest that because they are a conservation facility that has the capacity to preserve and protect those artifacts in a way that the artifacts will then be maintained. And the state then has the capacity to disseminate artifacts from them after they have been received by the state. So they do not have to stay finally at the state, but because of the care that the state can provide, that is the recommendation of the staff.
So at some point, once they're cataloged and everything, the state could release those artifacts.
Correct.
Nothing further, Mr. Chair.
Are there any other questions? Seeing none, is there a motion?
Yes, Mr. Chair. On consideration of the record and the technical staff report, I move that we adopt the findings and recommendations of staff along with the revisions thereto to the findings on page 8 as set forth in the applicant's exhibit and condition 5. Accept that of the applicant's exhibit and approve PPS 22067 Type 1 Tree Conservation Plan TCP 1-2025-0030 and variance to section 25-122B1G.
Second. Been properly moved and second. I will now call the roll. Vice Chair Giraldo.
Vote aye.
Commissioner Okoye. Aye. And I vote aye as well. That concludes all items on today's agenda. I'd like to thank the staff and others for their came out today. The time is now 2:55 and the meeting is now adjourned.
Thank you for